I'm back once again. I want to talk about the right of access. Yesterday, y'all saw my video that I posted yesterday. I was telling y'all about experience that I had where I was trying to obtain a copy, a certified copy, not just electronic or PDF copy, but it's a certified copy of the judge's oath that's over my case. And you can go back and listen to that video to kind of get more context as to what happened during that experience. But in the beginning of that journey, the first lady that I spoke with, she said that they don't generally give out copies of the judge's oath to people, and I expressed to her that it's the law that she does have to give it to me. She didn't challenge me on it. But I wasn't rude about it, and I wasn't contentious at all. So I was just like, oh, but by law, you actually do. You have, if it's requested, you do have to give it to me. And so, and I said it in that tone. So, but I was just really polite and just like, she started asking me who am I and all this different stuff and why do I need it. Now, and keep in mind what I just said. She did ask why I needed it. So, and that's really not her damn business why I needed it, but. At the same time, I didn't have a problem telling him it was, he's presiding over a court case in my county, and I want to get a copy of his oath. I don't have a problem telling her why. It don't matter. She can't stop that. She still by law has to give it to me. So I thought so that prompted me to, that kind of invoked this kind of, this video. That's why I made this video, because I wanted to kind of show you all a few states that I'm going to cover, only maybe 2 or 3. I think I'm gonna do California and North Carolina as well. But I'm here in Georgia, so y'all know I gotta do Georgia. But this is the code right here. Title 50, Chapter 18, says 71, but it's Article 4. And as a matter of fact, I'm gonna go right there so y'all can see. It's the menu right there. This is basically gives the breakdown of concerning this topic about public records, inspection of public records. Okay, and I started with right of access, which is right here. Now, all public records shall be open for personal inspection, copying, inspection and copying, except those which by court order of this state or by law are specifically exempt from disclosure. A record shall be maintained by agencies to the extent and in the manner required by Article 5 of this chapter. We have not gone to Article 5 yet, but we're not going to go there. Now, for the sake of time, we're just going to kind of keep it simple. I just want to show you all what some of this stuff says about, your right to be able to access it. Agencies shall reproduce for inspection all records responsive to a request within a reasonable amount of time, not to the extent of 3 business days, except of the request. Keep in mind, it says not to the extent of 3 business days of the receipt of the request. Provided, however, that nothing in this chapter shall require agencies to produce records in response for a request if such record did not exist at the time of the request. So if they don't have it in their records, then they can't give it to you. Can't ask them for something they don't have. So in those instances where some, but not all records are available within 3 business days, the agency shall make available within that period those records that can be located and produced. So if they haven't produced it just yet, but it's about to get done, then they have to produce it. That's all it's saying. So. In any instance where records are unavailable within 3 business days of the receipt of the request and responsive records exist, the agency shall within such time period provide the requester with a description of such records and the timeline for which for when the records will be available for inspection or copying, and provide a responsive record or access thereto as soon as practicable. Okay. B says a request made pursuant to this article may be made to the custodian of the record of the public record, orally or in writing. Okay. That's when you can even call over the phone. You know, the city request can be made pursuant to this article. It can be made to the custodian. That's the ones who have the record of the public record, orally or in writing. You can either. I had to. Me being my father's caregiver, I had to get I wanted to get a copy of their marriage license when he and my mom got married, and you know, for some some legal reasons concerning his him being a veteran, some business concerning his veteran stuff, and so I had to go to the county in which they were which they were married, and I pretty much called them over the phone and asked them if they would send it to me, but they told me they wanted it in writing, and so I sent them just a an ID, because I'm in Georgia and they got married in Florida, so I guess they wanted to know who was that was getting it, but I sent them a picture of my passport and I think I had it attached to the request, like a photo inserted into the request itself, and they sent it right on to me. It was no problem. Now, there was a divorce decree as well. They divorced in the same county that I was born, so I had to obtain one of those as well. I called that county and asked them for a certified copy of the divorce decree, and all I had to do was ask them over the phone. They didn't worry about anything in writing. All I had to do was just ask for it, and I paid for it over the phone. She put it in the mail, and I got it. So that's an example of what they're talking about right here. That's a public record. Okay, so it's not a public record is not limited to an oath, but it's any type of public record. Okay, an agency may but shall not be obligated to require that all written requests be made upon the respondent's choice of one of the following: the agency's director, chairperson, or chief executive officer. However, dominated. Sorry about that. Let's see, the senior official at any satellite office of an agency, a clerk specifically designated by an agency as the custodian of an agency of the agency records. Or duly designated open records officer of an agency, provided, however, that the absence or unavailability of the designated agency officer or employee shall not be permitted to delay the agency's response. At the time of the inspection, any person may make a photographic copy or other electronic reproductions of a record. Using suitable portable devices brought to the place of inspection, and it says, notwithstanding any other provision of this chapter, an agency may, in its discretion, provide copies of the record in lieu of providing access to the record when portions of the record contain confidential information that must be redacted. Okay, that's when they're talking about confidential information, that means like social security numbers and stuff like that, medical records, stuff like that don't have to be, you don't have a right to get somebody else's stuff, some public record that includes other people's personal information in there. They'll have that redacted. I've done something as far as like when I wasn't supposed to do it, but I had filed something in the county recorder's office. It had some sensitive information in there, and I didn't think about it until I actually filed it. But then when I got a certified copy of it, they had it blacked out. So anybody that got a copy of that record, it would be blacked out anyway. Let's see, because it's a permanent record. So if it's a public record, you want to make sure that the person, the personal information is not available to the public like that. It's personal. Say any agency that and it was probably like maybe a social or something like that, it was some sensitive information. They don't even want you to put, like, say if anybody look at a child support case, notice when they mention a child in an official original petition or whatever, claim or whatever, the summons, you'll see they don't put the child's whole birthday in there. They may say like born and then they say the year, but they don't have the birthday of the child, so they're limited there. That's not too much information. You're just saying what year the child was born, but you're not putting the whole birthday on the paper. Okay, any agency that designates one or more open records officers upon whom requests for inspections or copying of records may be delivered shall make such designation in writing and shall immediately provide notice to any person upon request, orally or in writing, of those open records officers. If the agency has elected to designate an open records officer, the agency shall so notify the legal organ of the county in such the organ of the county in which the agency's principal offices reside. I just had a thought interrupting me while I was reading that. Probably I was thinking about when you go to a vital check and you say you order a certificate of live birth. Keep in mind that's a spot where anybody in any state can go online and order, say, a certificate of live birth, and what they'll do is contact the agency of the county where you were actually born, where that certificate of live birth would actually be located, and that's how they obtain that record from that spot. Not so they don't. Vital Check doesn't have those documents themselves. They're like a go-between to get that document. So that's pretty much what it's like, a third party, interveners or whatever. So you're getting it through Vital Check, but they got to go to the place where you would have had to go if you'd have drove or you'd have called yourself and got it from that county. You actually could have done that yourself instead of going through Vital Check. You actually could have called the county in which you were born and just asked them, am I able to get that? And they probably would have either asked you to send something in writing or request in writing, or you could have paid for it over the phone and they would have mailed it to you. So using Vital Check, a lot of times you probably don't even have to, but hey, it's your choice to make. But I just had a brain fart then thinking about that. So while I was reading this statement, that's how I froze like that. Say, okay, I'm gonna start that sentence over. If the agency has elected to designate an open records officer, that the agency shall so notify the legal organ of the county in which the agency's principal offices reside, and if the agency has a website, shall also prominently display such designation on the agency's website. In the event an agency requires that records be made upon the individuals identified in the subsection B of paragraph 1 of this subsection, the 3-day period for response to a written request shall not begin to run until the request is made in writing upon such individuals. The agency shall permit receipt of written requests by email or facsimile transmission, in addition to any other methods of transmission approved by the agency, provided such agency uses email or facsimile in the normal course of its business. Say the enforcement right here, number 3, the enforcement provision of Code Section 50-18-73 and 50-18-74 shall be available only to enforce compliance and punish uncompliance when non-compliance when a written request is made consistent with this subsection, and shall not be available when such request is made orally. Right here, as you see right there is a punishment there. You cannot make this request and then they choose not to fulfill that request. Okay. I want to go ahead and fall back out of reading the rest of this because they don't even read the whole thing right now, because that's not. It talks about the fees and the process of how it goes or whatever. But this, I just want to I'm more so concentrating on the enforcement of it. Okay. Now right here it says 73 and 74. Okay, right here we're on 71. So I'm gonna back out and go to 73 and 74. Okay, 73, jurisdiction, say good faith defense to an action. I'm gonna read the part that talks about the punishment. Let's see, any action brought, let me see. guess I'll read both of these. The Superior Court of this state shall have jurisdiction in law and in equity to entertain actions against persons or agencies having custody of records open to the public under this chapter, under this article, to enforce compliance with the provisions of this article. Such actions may be brought by any person, firm, corporation, or other entity. That means, yes, they say a person, but goddamn it, there's commercial talk. But goddamn it, you can goddamn bring an action against somebody. Okay, so just don't get so caught up on, cause it say person, it don't say man. Y'all stop that shit. Anyway, in addition, the attorney general shall have authority to bring such action in his or her discretion as may be appropriate to enforce compliance with this article, and to speak either civil or criminal penalties or both. In an action brought to enforce the provision of this chapter, in which the court determines that either party acted without substantial justification, either in not complying with this chapter or instituting the litigation, the court shall, unless it finds the special circumstance exists, access in favor of the complaining party reasonable attorney. Hold on, the complaining party reasonable attorney's fees and other litigation costs reasonable incurred. So that means that person had to pay for all that, whoever's guilty. Whether the position of the complaining party was substantially justified shall be determined on the basis of the record as a whole, which is made in the proceeding, for which fees and other expenses are sought. Okay, any agency or person who provides access to information in good faith Any agency or person who provides access to information in good faith reliance on the requirements of this chapter shall not be liable in any action on account of such decision. So basically, if they were doing their job and they did exactly what they're supposed to do according to this chapter, according to this area, these laws right here, this whole thing right here, then you can't get no remedy if they're doing their job and you're just bitter about it. Okay. So, but if they're going against what this thing says right here, and this says that you asking for a particular record that they actually have, like say you're trying to get a judge's oath and they're trying to pretend like they don't have to give it to you. Now they're breaking the law now. Okay. But if they're saying that there's not one on file, like my phone call yesterday, the lady was like, he hasn't worked in his office in years. He's a senior judge now. So we don't have one here. We don't know what he has. We don't know what he's done. He hadn't worked in his office in years. So I was going by my assumption that he worked in Dawson, Georgia, the judge that is. But only because that's the mailing information that I saw on the Bar Association website. So I was going with that presumption that that's still applicable. I can still use that information. It's updated. But obviously he can receive mail there, but he ain't actually working in that office. So that could be a possibility. So me finding out that he's a senior judge, that's how and me talking to him on the phone, asking him about his oath, he told me he just gave me the nuggets that he was actually sworn by the governor himself. So I just thought I'd go to the to the governor's website. Governor Kemp is the governor here in Georgia, and so I went to the website. And when I went to the website and I went to the open, pretty much did some clicking or whatever and got the contact information. And I called that lady, and that's how I got the phone call. But I can't hold a woman accountable who said that he hasn't worked in his office. We don't have any record of him. We don't have anything updated. The thing is that he took, he probably updated many oaths over the years because he's almost 30 years in the game. Because they have to update the most I think it's like every 4 years. So she didn't have nothing updated for me. So I can't try to bring a charge against her pursuant to these laws when she don't have what I'm asking for. So that's what this is saying right here. So I thought I kind of give give a little example of what this thing is saying. Now, here's the penalty. Let's get to it. Any person or entity knowingly and willfully violating the provision of this article by failing or refusing to provide access to records not subject to exemption from this article by knowingly and willfully failing to or refusing to provide access to such records within the time limits set forth in this article. Remember, it said 3 business days. Remember, say by knowingly and willfully by knowingly and willfully frustrating or attempting to frustrate the access to the records by intentionally making records difficult or to obtain or review shall be guilty of a misdemeanor upon conviction shall be punished by the fine of not to exceed $1,000 for the first violation. So that even if they're trying to stall you out, they're giving you the runaround, they're trying their best to stall you out so they don't have to give it to you, they still guilty of $1,000 fine right there. You are not to exceed $1,000 fine. Okay, they're guilty of a misdemeanor. Okay, now alternatively, say a civil penalty may be imposed by a court in any civil action brought pursuant to this article against any person who negligently violates the terms of this article in an amount not to exceed $1,000 for the first violation. A civil penalty or criminal fine not to exceed $2,500 per violation may be imposed for in each additional violation that the violator commits within a 12-month period from the date the first penalty or fine was imposed. So after they got hit with $1,000 fine and they keep on doing it within a 12-month period, they're gonna get hit with a $2,500 fine each time they do it within a 12-month period. Say it shall be a defense to any criminal action under this code section that a person has acted in good faith in his or her actions. Say say in addition, persons or entities that destroy records for the purpose of preventing their disclosure under this article may be subject to prosecution under code section 45:11 and 1. Let me see what that is. I'm just gonna play with that just for a hot second. I ain't gonna stay on there, y'all. I'm just gonna glance at it. Just go glance at it. Let's see. 5:11. Okay. Ooh. It's a lot of commas in there, y'all. I want to see the punishment. Wow. Okay, I just want to glance at that real quick. I'm gonna stay on topic. Okay, so it gets even worse when they go to trying to destroy the records so that you can't get hold to it. So they're looking at some serious time on that one. Okay, now a prosecution under this code section may only be commenced by issuance of a citation in the same manner as an arrest warrant for a peace officer. That would be like a deputy sheriff then, wouldn't it? For a peace officer pursuant to code section 7. Okay, I'm gonna just look at that code section. So this is how they received a citation. Say such citation shall be personally served upon the accused. So you can have them served at work. The defendant shall not be arrested prior to the time of trial, except that the defendant who fails to appear for arraignment or trial may thereafter be arrested pursuant to a bench warrant and required to post bond for his or her future appearance. It's just like when you get a ticket or whatever, and you don't go to court, and then, it's the same process. Okay, let me see what this thing's talking about right here. Okay, maybe warrant. not gonna read the whole thing because we ain't trying to get there right now. Let me see. Let's see. Let's say persons who may issue warrants for arrest of an officer against penal laws. Warrants requested by others. Persons who may issue warrants for arrest of law enforcement or peace officers, or school teachers or administrators. Say any judge of a superior city or state or magistrate court or any municipal officer clothed by law with the powers of a magistrate may issue a warrant for the arrest of an offender against the penal laws, based on a probable cause, either on the judge's or the officer's own knowledge, or on the information of others given to the judge or officer under oath. Okay. And see, this is where we be kind of side-eyeing because we know a lot of them work together and they probably, feel like it's going to be some type of how they look out for each other. And then you just have to be willing to go to a higher court if you have to, and have the judge who don't want to do their damn job, you can have them goddamn arrested. Okay. Any retired judge or judge emeritus, judge emeritus of the state court may likewise issue warrant arrest if authorized in writing to do so by an active judge of the state court of the county wherein the warrants are to be issued. Say if the application is made for a warrant by a person other than a peace officer or law enforcement officer, and an application alleges the commission of the offense against the penal laws, the judge or other officer shall schedule a warrant application hearing as provided in this subsection, unless the person accused has been taken into custody by a peace officer or a law enforcement officer. Okay, I was making sure that when I said peace officer, this is why I'm reading in slow motion. It keeps saying peace officer. I want to make sure I'm saying when I see peace officer, they're not talking about a police officer. But normally when they say peace officer, they're talking about maybe like a deputy sheriff or something. But a law enforcement officer, we know those are the police. So let me kind of throw this in here real quick, because I be studying while I'm reading. Y'all know that, so y'all already, I ain't got to tell y'all that. Okay, peace officer. Y'all know I like U.S. legal. A peace officer is generally a law enforcement officer. See, sometimes they are. Say which may include a variety of positions responsible for enforcing laws, such as police, probation officers, correctional facility personnel. And now, a lot of times, those are deputy sheriffs too. Juvenile justice employees, attorney generals, and others. The precise definition of a peace officer is governed by the laws, which may vary state by state. That's not helping me in this one. Let me go back to the definitions area of this spot right here. Let's go back here. Y'all know that's why I always tell you got to go to the definitions, see what the definitions say. Definitions. I'm not gonna stall this out too much, y'all. Let me see. Let me see. Got this right here, 74. But I already read pretty much the violations for the most part. I just want to see what they mean by peace officer when they're using it here in this particular article, in this particular title. Definitions, here we go. Agency, public record. They didn't give me enough definitions. Not in that area. I guess it could be a police officer as well. We're gonna see though. I'm gonna do one more one more check. Didn't I just click here? Yeah, I just clicked there. Right of access. Yeah, I don't see it. Anyway, I think I'm gonna end it here, y'all. Ain't no need me dragging it out. But, oh, no, I'm not. I said I'm gonna do a few more states. Here we go. North Carolina. I want to point out right here. Is there a time period for the agency to respond? Let's see. Let me see. I'm going to kind of glance across this here. This is from the North Carolina Judicial Branch. Say about North Carolina Public Records Law. It say this documents and material made. That's what the public records are. Documents or materials made or received by a government agency in California, in North Carolina, while conducting public business. Say our only public paper documents, public records. We know better than that because there's a lot of other stuff that could be public records. Who may inspect or copy? Any person has the right to inspect, examine, and get copies of public records. Okay, it says the same thing in North Carolina. This is gonna be all across the nation, y'all. So I just want to pick out a few more states. I know y'all tired of me doing Georgia all the time and don't do no other states. Which government agency must permit, inspect, or furnish copies of public records? All state agencies must permit, inspect, and furnish copies of public records. These agencies include all public officers and officials, elected and appointed, staff members, institutions, boards, commissions, bureaus, departments, authorities, and other units of government. Counties, city, and town governments are included. So even like keep in mind, this is even when you're doing like medical records and stuff like that, they all government. All that's government too. So you can even get certified copies of medical records, certified copies of judge's oath. You can get certified copies of laws. Certain laws you want. The Constitution, you can get certified copies of. Any public record you have there, all state agencies must have them. They must permit inspection and furnish copies of these records if you need it. They have to do it. Say, is there a specific procedure for requesting the records? No, the law does not specify a procedure, and there is no specific form provided in the law. That's here in North Carolina. Thing is, you can ask for it. You can call and ask for it. And what do I have to do to obtain that? And they'll tell you what you need to do. Sometimes they'll tell you, they can mail it to you. Some of them they tell you got to, you can whatever. There's different ways to get it done, but you don't have to leave your house all the time either. Sometimes you do need to leave your house. Me myself, I find it more convenient for me to go get it if it's right down the street. If it's right here in my city, why not go pick it up? And say this, cause they mail it to you, you gotta wait 3 days to get it. You might as well go there and get it. You have it in an hour. Or whenever they say it's available for you. Okay, is there a time period for a government agency? Remember, I said three days here in Georgia. Is there a time period for a government agency to respond? The law states inspection and examination of records should be allowed at a reasonable time and under the supervision of the agency. Agencies are required to furnish copies as promptly as possible. Agencies are not required to provide access for inspection or copies outside normal business hours. Of course, you got to catch them when they're open, but they just use these quotation marks and say as promptly as possible here in North Carolina, or there in North Carolina, reasonable times. In Georgia, they give specific 3 days. Okay, so you got to read in your state to see what it says. Okay, can a citizen request copies of public records in any media available? If the agency has the capability to provide copies in different kinds of media, for example, in a print or computer disc, requester can ask for copies in any and all media available. See, the agency is not required to put a record on electronic form. In electronic form, if that record is not already kept in that medium. If it's not already in electronic form, you can't make them do it like that. It's like, for example, I had to get some of my father's medical records from Florida because he's a veteran, but he's been in Florida most of his life. Okay, and he's been with me for the last 2.5 years, and so I had to get some of his medical records from Florida, one of the VA clinics in Florida. And the people called me after I made the request. I sent the written request with a picture of my ID so they know who I am, with a picture of the copy of my power of attorney as well. So the guy called me and asked me, because it's a whole lot of documents. It's like 700 something pages. So he was like, is it okay for me to send it on a disc? I said, sure, that's cool. And I'll print out what I need, because they don't need to print out a bunch of paper that I probably won't even need anyway. I only pick out what I need. But he put it all on disc, and it was a hell of a lot easier and more convenient for him as well. So that's what he sent me, and that's what I have. So that's the medium there. That's an example of what they're talking about right there. Must the public agency provide information in verbal form? Well, they don't have to. Let's see. No, the law does not require that government agencies provide information verbally. They ain't gonna tell you too much verbally anyway. They'll just, like they ain't gonna give you. I guess I would take that as them not want to give legal advice. They quick to tell you that. Must an agency create or compile a record upon request? Say no. The agency is not compelled to create a record that does not already exist. That's common sense there. So how does an agency handle records that contain confidential information? We talked about this a few minutes ago. If a record contains public and confidential information, the agency may separate or redact the confidential parts. If the entire document is confidential, the agency is not required to produce the record. That's what I was talking about when there was a certain part of a document that I recorded in the county recorder's office, and I went to get a certified copy of it. It was blacked out. The sensitive part was blacked out, but I received the whole record. It's just that sensitive information was blacked out. So just imagine, like, say if you use a medical record as some type of certified copy of medical record in your case, in a court case or whatever. Like me myself, I went and bought a confidential stamp so that they'll be cautious about what they're about to file, what they're about to make public, and they'll see this as confidential. They may glance and see, oh yeah, these are public records, and then they'll pause and they know to redact that. They'll make it to not make it public to where somebody can go look it up. You know what I'm saying? So that's an example right there too. Let's see. May any agency charge for public records? Yeah, they're gonna charge you. They're gonna generally charge you anyway. May not charge. Government agencies may not charge for inspection of records. I say fees may be charged for copies. Now this is true right here, because I go to the county recorder's office where I go there and they'll let you go in there and use their computer to go look up stuff. So you can look at it all day and see what's in a court case, what's been in there. But if you want to make copies, then you gotta pay for the copies, and you'll pay a couple more dollars, just about $2 or $3, maybe $4, whatever, for certified copies of it. You know what I'm saying? But it's not expensive at all. So fees fees for certifying records are to be charged as prescribed by the law. Okay, see right here. Say if making copies involving extensive clerical or supervisory assistance, the agency may charge a special service fee in addition to actual duplication costs. Let's see. This service charge must be reasonable and based on actual labor costs. Say the agencies may also recover a cost for mailing copies. Yeah, that makes sense. It's fair. I mean, they stopping what they're doing to help your ass out. You should be able to pay for something. Let's see. Person requesting copies. Let's see. I guess this is the actual law they're talking about. So I'll let y'all pause and read that, and then I'm gonna go ahead and move forward. Okay. I ain't trying to stay there. Okay, now I'm done with North Carolina. Now let's go to Texas. Texas says the same thing. Right of requests. They say you have the right to prompt and access the information that is not confidential or otherwise protected. Say receive treatment equal to all other requests, including accommodations in accordance with the Americans with Disabilities Act requirements. Receive certain kinds of information without exemptions, like the voting record, like the voting records of public officials and other information. Receive written statement of estimated charges when charges will exceed $40. I ain't never seen. Anyway, in advance of work, let's see. In advance of work being started, in an opportunity to modify the request in response to the itemized statement. Let's see. They have the right to choose whether to inspect the requested information, most often at no charge. It's the same thing, y'all see. It's saying the same thing said in my state and North Carolina as well. It's all saying the same thing. So this is Texas. So let me see. Responsibility, government bodies. Let's see. All government bodies responding to information requests have the responsibility to, let's see, establish reasonable procedure for inspecting or copying public information, and inform requesters of these procedures. See, treat all requesters uniformly, and shall give to the requester all reasonable comfort and facility, including the accommodation in accordance with ADA requirements. Sounds like this right here. Yep, American Disabilities Act. That's what ADA stands for. Say, be informed about the open records law, and educate employees on the requirements of those laws. So it's basically telling you the same thing. Is in every state they have to give you that stuff. Let's see, procedure. Let's see, procedure to obtain information. Let me see if let's see, information may be held due to exemption. That's when you're talking about sensitive information. Let's see, information. I should have looked for that. Okay, I didn't look for the punishment. I'm really kind of browsing now because I think I've gone far enough. This damn video is 40 minutes long. California, same thing. Public Records Act, SPRA, gives you the access. Give you the access to public records we maintain unless they're exempt from disclosure by law. This may include written and electronic information. Exemption. This is what's exempt. We are exempt from disclosing certain public records or portions of public records. Here are a partial list of the exempt documents: personal, medical, personnel, medical, or similar files for FTB employees. I don't know what FTB is, but anyway, test questions and scoring keys for employment exams. Preliminary drafts of documents not retained by us. Records pertaining to pending litigations. See, y'all see, this is stuff that you don't need to be knowing all that anyway. Some people want to know, people want to look in people's court case, and the case is already it's still going, still pending, and they want to go all in and try to see what they can look in there. You can't do that. It's still going. Let's see, what can you request? Let's see. Okay, this is pretty much saying the same thing. It's the same thing all the other states say. But I'm gonna go ahead and end this video because y'all know I get a little antsy when these videos get too damn long. I know some people, the attention span be a little too goddamn short anyway. So I'm gonna go to get up on this video, y'all, and we'll catch y'all in the next video. If you haven't liked and subscribed, please go ahead and do that right now. Share these videos, share it with your people. If you know somebody from these states, some people that you might have had debates with about this topic, share it with them so they can educate themselves. Look at this type of stuff. You got to be able to see how to play the game how to play by the rules. Okay, and if you got any questions, any comments, please go ahead and share that in the comments. And I don't have a problem making a video if it's something I can make a topic out of it. And we'll get at y'all later, y'all, in the next video. Emerald signing out.